with that, on to the next panel. Welcome, everyone. So this panel is on fitness, and we're very fortunate to have with us five experts on fitness. The law of fitness, as you know, is in flux at the minute. There's an interesting case that came out of the Court of Appeal yesterday you might hear about. That'll be part of your materials. Warm welcome, first of all, to Justice Riun Shandler, who's kind enough to be here with us. Justice Shandler of the Court of Justice in Ontario was appointed a judge of that court in 2014. He presides in Toronto. Prior to his appointment, Justice Shandler worked at the Ministry of the Attorney General, Crown Law Criminal, and he's the co-author of Mental Disorder in Canadian Criminal Law, Carswell, together with Justice Joan Barrett, whom we'll be hearing from later on this afternoon as well. You have Carter Martell, who's an expert from the defense bar on the issue of fitness. And Carter got his undergraduate degree at the University of Edinburgh in 2007 and went to the U of T Faculty of Law, the highest calling, is it? And by the way, everybody's bios are in your materials and were circulated via email. We have Dr. Maryana, Dr. K, who's currently at CAMH, but comes to us from out west, and you'll be hearing about her expertise and experience in doing fitness assessments. And last but certainly not least, Coughlan from Scarborough Crown Attorney's Office, who has played a lead role in mental health issues in that office and is currently the Toronto East representative in Toronto's mental health court. So welcome to our second panel on fitness, and thank you.
All right, so we'll jump right to it. We'll start with you, Carter. As Anita said, the law on fitness is in flux. Can you take us through a crash course on the law of fitness?
So in 2023, the Ontario Court of Appeal released a decision called Bharwani, which didn't change the law of fitness, but did more clearly articulate how the fitness test is to be applied. And it addressed some criticisms that have been made over the years about the Taylor test, as it was known prior to Bharwani. One of the aspects of practice that had grown up around the previous jurisprudence is the reliance on a series of questions known as the Taylor questions, which focus on the accused's understanding of some of the fundamentals of a criminal trial. What does the Crown do? What does the judge do? What happens if you're convicted? And so on. Bharwani says, at times those questions have been used as if they were the fitness test. If you get them all right, then you're fit. Bharwani says those questions are helpful, but they're not determinative. Fitness can at times be more complex than those questions capture. The case says in order to be fit to conduct a defense or instruct counsel, the accused must have a reality-based understanding of the nature and object and possible consequences of the proceeding. And they must have the ability to make decisions. So that means being able to understand their options and the basic consequences of those options and intelligibly communicate their decisions to counsel or to the court if they're self-represented. This inquiry is contextual. It has to focus on the particular proceedings that the accused is facing and the kind of decisions and issues they're going to have to navigate in the context of those proceedings. Bharwani is currently on reserve at the Supreme Court of Canada. What's at issue at the Supreme Court is an additional component that Mr. Bharwani argued should be part of the fitness test, which is the capacity to make rational decisions in one's best interests. The Ontario Court of Appeal declined to incorporate that. It was chiefly concerned that engaging in any consideration of whether a person is capable of acting in their best interests risks kind of inviting in a paternalistic assessment of whether they're acting in their best interests, in fact, and thereby threatening their autonomy. My impression from watching the Supreme Court hearing was that some of the justices shared those concerns. They didn't seem hugely inclined to interfere with the Court of Appeal's articulation of the test, but we'll see. And just in the last week, the Ontario Court of Appeal released another important decision on the law of fitness, a case called Clayton. which emphasizes that the fitness assessment is contextual. It has to focus on the proceedings that the accused is facing. It was critical of the fitness assessor for focusing on whether Mr. Clayton knew what a fine was, which was not something that was a likely outcome in his case. And the court also says that part of that contextual assessment is considering the serious consequences to accused to being found unfit. Often means detention in hospital, sometimes forcible treatment with medication, and that consequence as compared with the likely outcome if the accused is found guilty. So, in other words, courts should strive to avoid having people taken out of the criminal process and subject to detention and treatment because it's uncertain whether they're able to defend themselves for some minor charge.
We'll keep it with you just for one more, Carter. How does the defense raise fitness?
So acting as defense counsel for a client who appears, unfit or where fitness is uncertain can be extremely challenging. There's a number of kind of ethical and professional dilemmas that can arise in those cases, and your obligations are not always clear. Being found unfit, as I said, has serious consequences for the accused. Sometimes a fitness assessment, reveals serious mental health issues that can start the ball rolling towards an NCR verdict that might not be in the client's interests. So you don't want to start down the process lightly, but you can't act without instructions. So if you have fitness concerns and they're persistent, then you have to raise it with the court. I think how you do it will vary from case to case. It's helpful to give the court a sense of what the specific concerns that you have are, being mindful, of course, that you don't reveal any confidential or privileged information or anything that's going to prejudice the client. Yeah, I think these are tricky cases, and if you're dealing with a fitness issue for the first time, it's a good time to reach out to one of your more senior colleagues so that you can kind of talk through the issues and how you might raise it and what role you'll play at the fitness hearing if it comes to that.
And Craig, from a Crown's perspective, when the defense does not raise fitness, but you have concerns about an accused person's fitness to stand trial, what are some of the things that you might do?
So you're dealing with a lot of secondhand information up front as a Crown, usually in these situations. Oftentimes it'll come from defense counsel if they're mentioning something about not getting instructions. More often, if they're not raising the issue, you're going to see it first in the police notes. They might raise particular issues from their interactions with them or from past cases. But a lot of the times what you're dealing with is your observations of the accused person in court and notes from your colleagues from past appearances in court. And, by definition, what that means is you're getting a very surface level view of things. But when these things start building up over time, if a person has made several appearances in court and is not engaging with the court, or what's happening more and more these days, or at least in the last few years, is a person refusing to attend court and refusing to engage even on a video appearance or refusing to come to court at all. Those really start raising red flags about whether the person is able to participate in the system as opposed to simply choosing not to. And, it's not something you can rush into as a Crown. People engage in the system in all sorts of different ways, and some of them are not to their benefit necessarily up front. But you are looking for certain things that give the sign that they're just not engaging at all with the system. Appearances, only run so deep, but often that's what you have to work with. But you should be looking at whatever background information you can get to try to, at least in your own mind, decide, is this something that's volitional because they're upset in the moment, or is this something that's been more of a long-term issue that people have noted over time?
And I'll turn a similar question to Justice Shandler from the bench. The defense hasn't raised fitness, the Crown hasn't raised fitness, but you have a concern. What does that look like for you sitting as a judge?
Well, so I can tell you as a starting point, I apply restraint before I go down the fitness road. We talk about applying the fitness text contextually, and part of that context is the profound implications it has for an individual, either while they're being held for an assessment, or if they are having a fitness hearing, or if they're ultimately found unfit. So I apply a lot of restraint, and I want to know a little bit about the individual who's before me. And we're lucky in Toronto because we now have this electronic information. So some of that information is at my fingertips. I can see from my desktop the arrest date, the recency of the arrest. That's important context for me, because if the individual is presenting in a fashion that is causing me concerns for their mental state, but I know this is a new arrest, well, maybe there are some other things at play, and I can ask the parties, what their position is in terms of, is a therapeutic adjournment maybe required here? Context can involve trying to assess by a direct conversation with the individual what is going on with them. Maybe they're angry, justifiably or not, and maybe I can let them vent for a few minutes. And from that process, I can see whether or not what's at play here is simply anger, volition, or there's something that I have to probe a little further on. The most challenging for me are the individuals who are not engaging. And that sometimes happens even in our mental health courts where they're brought, but they're just not responding to anyone's questions. So we're asking, will you sit down and talk to duty counsel? Will you explain to me why you don't want a bail hearing? Those kind of things. Those conversations are impossible to have when somebody is in a cell and there's a court officer holding up a phone and they're not engaging. And those are, for me, the most challenging ones in terms of next steps. What can we do for this individual to try and understand what the essence of the problem is? And I want a handle on that. I want to know what the problem is before I start going down the fitness road. It's a last resort for me.
So I know from my experience before, some judges, if I have a client who is angry and venting in court, there are many judges who in very busy courts will just say, enough, that's not happening in my court. It's too busy. I don't have time. How do you balance managing what I'm sure is a busy court with allowing somebody to have that space to vent in your courtroom?
We're lucky in Toronto because we have a mental health court and we really draw on the expertise of the people who are in that court, the mental health court workers, the duty counsel, the crowns, the forensic psychiatrists. But to my mind, I control that courtroom, and I will happily allow an individual express themselves for 5 or 10 minutes if that is going to get me to a place where I can move forward for them. That is time well spent. I don't think I can give them much more than that, quite frankly. But at the 10-minute mark, I can then sort of engage and say, okay, I hear you. Now let's try and have a conversation. And if we can do that, that's a great thing. If we can't, well, then there's other steps.
Once we're at the point of fitness having been raised, whether by defense, crown, judge, I'll start at the other end of the table with Craig, and maybe we could move down the line from there about what happens next.
So because I'm in mental health court a lot, as His Honor said, we're lucky is there's a pretty quick process that we can engage in when it is. So we can have the Form 48 assessment order made, that's made by the judge. If the test is met, there's reasonable grounds to believe that evidence from the assessment will assist the court in terms of the determination of fitness. We have forensic psychiatrists who are there each and every day. And so we have those orders made in the morning. The psychiatrist is there over lunch and sees the individuals, and then we can conduct fitness hearings in the afternoon if required. I think that that's a particular luxury that we have. But otherwise, the process would be the same in terms of a fitness assessment can be ordered, and then finding a forensic psychiatrist who's available to take that on if you don't have one, coming at 1 o'clock on a daily basis. Then once the assessment is made and you get the report, whatever it might be from the assessor, you can move on to hearings if required.
Carter, what's happening next on the defense side of things after fitness is raised?
Well, I think it depends on, who's raised it, and, defense counsel's role and what happens next. I think depends what your view is of whether you feel you can get instructions, they're reality-based and so forth, from the client and what's in the report. I think the most important thing as defense counsel is to remember that you are the lawyer for the accused. Your job is not to act in what you perceive to be their best interests, but to take their instructions when you can. And, if you can, then you can protect their legal interests and make sure that the correct test is applied and the correct processes are being followed. And to get advice whenever you're not sure about what to do. But I think if you keep that as your North Star, that you are their lawyer, and then you won't go too far off track.
So I think this is the point, Dr. Kravtsenyuk, when you get involved, what is your role in a fitness assessment? What does a fitness assessment look like?
So thank you. I think at the point where when I receive Form 48, and I sort of, maybe I'll step out and start with, from forensic psychiatrist perspective, when Bharwani came on board, the question we had, this really raised the threshold. Is there any change in our approach? Did actually fundamentally change how we do or how we see the assessment or how we apply the test during the assessment? And to be honest, from my experience, and I have worked in different jurisdictions, in different mental health courtrooms in Alberta and in Ontario, the answer is no. It did not fundamentally change how forensic psychiatrists will apply the test to conduct the assessment. It might draw the attention to some nuance in the assessment, and particularly when we think about meaningful presence and meaningful participation. So that's sort of one aspect, and kind of looking broadly at this issue from forensic psychiatrist perspective. Then when I do get the assessment, I think I have to be mindful. Working in the mental health courtroom is a luxury in itself, because these are not really commonly, I think, introduced courtrooms in the justice system across different jurisdictions. So sometimes justice participants end up approaching forensic psychiatrists to do fitness assessment outside of a mental health courtroom. So in mental health courtrooms, the assessments are fairly, I would say, robust, fairly focused, and it's really depending on the amount of information in front of me and on the state of the accused. So the more information I get as a forensic psychiatrist in a mental health courtroom on the balance of probabilities fairly quickly, I can derive to my opinion and provide that to the court. In another context, when I function outside of the mental health courtroom and the fitness or the case is a bit more complex and nuanced. And even in the mental health courtroom, I think several participants on the panel mentioned we really have to take into consideration the context and the complexity of the case. So number of times in the mental health courtroom when cases are a bit more complex, a bit more nuanced, you will very frequently hear, well, forensic psychiatrists could not derive to the opinion. We need to refer to more extensive assessments. In mental health courtroom in Toronto, we call it BAU, Brief Assessment Unit, and that allows additional time to bring the accused to the forensic hospital for 3-4 hours. But during that time, not only forensic psychiatrist will have access to just have a mental status of the accused, but also forensic psychiatrist will have access to additional medical information that is very informative. I think these are kind of aspects of the assessment, but I can go more through details, Jacob.
Well, one thing that would be helpful, I think, for the defense lawyers in the room to know is what sort of information is helpful for you to get in doing a fitness assessment. And as a follow-up to that, what information is our defense counsel not giving you as often as you wish they would?
Thank you. Actually, last few weeks, I had a very good example of when I was provided additional information that was very crucial to really derive to the opinion that would be helpful and assistant to the justice process. But in a nutshell, the more information I receive, either from defense counsel or from the Crown, the more informed my decision is, because my opinion as good as the information that I based it on. So, for example, very often in mental health courtroom, I have absolutely no access to any records. I just see what I see, I get what I get, and very often I just get a Form 48 and nothing else. And the accused might not want to be cooperative or speak to me. And I have absolutely no collateral information of how this accused has been viewed or observed or described by any other court participant. So certainly, it's very challenging to derive to any useful opinion when you have only Form 48, an accused who doesn't want to talk to you and not cooperative and not exhibiting any very, I would say, clear, overt signs of some disorganized behavior, because mentally ill people, they could present more in a hyperactive, disorganized state that a little bit easier for us to diagnose and judge and really formulate. But some people that are sick, they might actually be more introverted and disengaged, and those are more challenging cases. So on the other side, I do get sometimes the legal counsel that will come and say, well, I have this report 3 years ago, but it's a little bit old, but has a little bit of clinical information. So I have, let's say I have accused who presents with certain mental status, but having that legal report that gives me a little bit more of snapshot of past clinical history, saying that this individual actually does have a history of schizophrenia since yada, 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 like 5-10 years ago, you name it. And the way individual will present in front of me and the information that is provided by the counsel really helps me to formulate on the balance of probabilities with reasonable degree of medical certainty of what is happening with respect to fitness. The other example, I don't know how many of you familiar with FICE? Can you raise your hands? Okay, so, I'll just give a little bit of, so FICE is Forensic Early Intervention Service. And this is, I call it, it's a Cadillac service of Toronto South Correctional Center. Only Toronto has this additional beautiful layer of mental health services for participants in justice system. And that service actually created around the concept to facilitate all this information to forensic psychiatrists in the courtroom. So recently, I had a legal counsel who comes to me. I had absolutely no information about the accused. I had Form 48. Counsel comes to me and says, you know, I just had this communication with Vice. See, this is email. This is what they share. This is what they talk. Vice is basically a group of forensic social workers, nurses, mental health therapists, and the email communication documented the interaction between Vice worker in the corrections and this individual, the accused. So it was very informative for me to gather that, to have it, and it was duty counsel that provided this for me. So having mental status of the individual was that information was really useful. So if there is anyone from here that is in mental health court in Toronto, we do have this additional service. Vanier has it as well. It's an additional vehicle that can be used by counsel to facilitate fitness assessment and really, I think, me to provide that more robust, quick opinion.
Sticking with the topic, Justice Shandler, on things that we can do to make the system work better. What are some things that counsel can do to make fitness issues run more smoothly than they currently do in your court?
Well, I was feeling quite sympathetic while I was listening to the good doctor talk about having a Form 48 and a client who didn't want to engage with her. I sometimes feel like that when I'm presiding and somebody's brought into the box and I'm invited to conduct a Taylor test with them. And they're looking at me going, and I'm looking at them going, can somebody provide me a little context? So whether it's a Crown who is familiar with the details of the arrest and some of the presentation that was happening during arrest or maybe behind the scenes, and they can say, Your Honor, I'm going to ask you to embark on this inquiry for the following reasons. Or if it's defense counsel that says, you know, I can tell you that while my client has some struggles, we typically are able to communicate. We're not able to do that now. I'm not able to get instructions. And that provides me as a starting point for my own inquiries in terms of how I want to direct my questions and what I'm trying to tease out. Because again, employing that sort of restraint model, I would like to, if I can, find out from the accused, is there an obstacle here that I can provide a support for? Something that will allow them to get progress on their case. And does that mean they need a little bit of time to consider their options? Does that mean they need some encouragement to sit down once again with duty counsel? Do they need another opportunity to talk to their counsel? They often understand some of the options, maybe not all of them, but they understand that they're in the box and they're not going anywhere. And in order to get some traction on that, why don't we talk about why is it that you can't provide or you won't provide instructions? So I think getting that context from counsel is very helpful, and maybe I'll now try and put onto the Form 48 for the good doctor. Getting instructions is a concern. Presentation is a concern, something that will perhaps give you some guidance as well. The only other thing I wanted to say about this, in my role as the judge, fairness is essential to the accused throughout the process. Procedural fairness is essential in this process. So what Carter and Carson say about whose onus it is, who's raising the fitness issue. I want to know that, and I want to know that clearly on the record. If it's the Crown, I want to know what their election is going to be, because that's going to inform the test that I apply for making an assessment order. I want to know that there is 672.24 council, fitness council ready if we are going to run a fitness hearing in the afternoon. The procedural protections that are provided in the code have to be applied in order to ensure that this individual isn't going down a fitness road unnecessarily. And if it's necessary, that all procedural protections are in place. So that's the other thing that I worry about.
And what happens, and I'll start with Craig on this, or what are the challenges that you encounter in dealing with an accused person who clearly raises fitness issues in your mind, but is not willing to engage with counsel, duty counsel, doesn't have their own counsel? How do you deal with those sorts of situations while upholding your role as a minister of justice?
So I think the procedural point that His Honor was talking about is important. I take the personal view, and I think it's right in law, that if before even an assessment order is made, there should be counsel on board. 672.24 counsel, should be on as early as possible if there isn't already counsel retained. And so I try to make sure that that is being done. The other concern that I'll generally raise is trying to think 2 steps down the road here. Where is this going to end up? Are we talking about saving a few days of time and putting the person on a path to what could be months of, being in detention or whatnot? Or is this something where it's better to have a bit of a cooling off period and try again in a couple of days and see, where they're at? If the person has managed to calm down, if there's substances involved and they've been able to clear the system like that. And it's something I've had to learn since being in mental health court, is that there's, you can't rush through these early steps because the long-term consequences are vast. While at the same time, trying to, as the Crown, make sure things are progressing in a way that makes sense. Often with people who refuse to come to court, it's a bigger problem, because that does raise flags right away to me that there's something going on here. But at the same time, the Crown is sort of being looked on to advance things. But how do you convince someone to come to court when you're not? Extraction orders are a thing. Nobody wants to put them in place for all sorts of very good reasons. But you reach the tipping point where it's, well, this person now hasn't come to court for 4 appearances, 5 appearances, 6 appearances. When am I then just saying, okay, the Crown's making the application for a BAU assessment so that maybe someone can go? Or the Crown's making suggestions like talking to the duty council and saying, can we maybe get someone appointed for legal aid who can go see this person in the jail, or use the institutional duty council services, something along those lines to help, get a little bit closer to where we need to be.
That cooling off period, Dr. Kravtsenyuk, is that something that you think is potentially helpful for some individuals presenting fitness issues? Is a few days to, as Craig says, just to cool off? Can that be an effective way to go about things?
As a clinician, I think it's not an uncommon practice. And let's look broadly. Currently, we know that every 5th Canadian, according to the Center of Addiction and Mental Health and Canadian Mental Health Association, will have at some point of their time, will have some mental health or addiction issue. Addiction is another just booming crisis out of a ton of different crises in society. And we do see these individuals dramatically overrepresented in criminal justice system. So it's not uncommon where you will hear from clinicians, well, I do have issues with fitness, but we need what we call therapeutic remand. I always ask, when I am given Form 48, I always ask, when did this person get arrested? How long have they been in detention? It gives me just a very rough idea of the time potentially that person has been in detox period, let's say. So I'm not naive to the fact that our jails are still struggling with addictions and contraband, but there is a less probability that that individual had access to any intoxicants the longer they have been detained. So Jacob, not uncommon that we will see clinician will ask court participants to really consider therapeutic remand. And nowadays also not uncommon to see it a little bit longer than we used to, because if you even look at the potency of cannabis over the last 10 years, it's dramatically increased from very, what they call clear, clean cannabis to quite contaminated, dangerous mixture of drugs. So these therapeutic remand periods might be a little bit longer than what we used to.
I was talking to my panelists before this presentation. I think the group quite liked the reflections from the prior presentation and that format. So we're going to steal from the prior panel the last question and just go down the line. We'll start with you, Craig, about what you see generally working or not working, and some of your reflections on the state of the law and practice as it relates to fitness.
Yeah, I think again, I'm approaching this from a bit of a privileged position in that I work in a mental health court. I have the resources available there. In my prior time when I was out of Scarborough before the amalgamation, we didn't have these sort of resources. We had a psychiatrist who came once a week for a half day. And so, you know, if you had fitness issues, as another panelist said, don't get arrested on Monday, Tuesday, Thursday, or Friday. So having all those resources there is an important, and, you know, I'm lucky to work in that environment where we have psychiatrists who are coming every day. We have specialized duty counsel who are in that court. And we have, you know, judges who are often in there who have a sense of things, that everyone involved. So that, I mean, that works because the system works. It's becoming incredibly overburdened even in our system. We have lists that now run 60, 70 people sometimes. And, you know, some of those are diversion cases where people are just checking in and then they don't take long. But then, you know, if you have 12, 13 individuals who are in custody and all have varying degrees of issues that need to be addressed. One of the things I've been trying to be cognizant is I'd like the court to be a full service court, do bail hearings, do guilty pleas, do fitness hearings, what we can do, but it can be tough sometimes. And so it's trying to, you know, differentiate between the people who really need the time and the people who don't so much need the time, because even in our very resource rich environment, it's sometimes limited.
Carter.
I think I'd just echo some of the things that we've said already and that other panels have said. You know, if you're working with accused who have mental health issues, you have to be prepared to move slowly and to put in a lot of time. You know, they might need longer than other clients to kind of build enough trust in you to start to engage with you a little bit. You know, might need to go and see them in person in the jail rather than just seeing them on video. Yeah, and reach out early and often to your colleagues if you're you know, if you're ever unsure about what to do.
Justice Shandler.
So I would definitely commend a close reading of Bharwani. I think it was a really significant decision from our Court of Appeal. And as they said, you know, they clarified the fitness test. For me, they removed a lot of the uncertainty about the application of the test and their articulation of the 8 guiding principles. I actually cut and paste into my bench book every time I go into mental health court. It is where I go back to. we spent a lot of our time talking about fitness at the early stages of the process. Bharwani, of course, was a decision about fitness during a trial, a rather lengthy and serious trial. What the Court of Appeal also said about the obligation of all the actors during that trial, the trial judge, the Crown, and significantly amicus, in ensuring that that accused got a fair trial is worth also reading and reflecting on. The Supreme Court of Canada has clarified the role of amicus. They expanded it to allow for an adversarial role. For those of us in the trenches, we have been asking for that for a really long time. For those of you who take on the amicus work, I'm ever so grateful. In many cases, for an individual facing serious charges with mental health struggles, they cannot have a fair trial without amicus. And fitness has nothing to do with that. It's all about fair trial.
So from the clinician in the courtroom, I could say that I don't think the intersection between mental health and criminal justice system has ever been this visible or more urgent. So certainly fitness is probably not uncommon concern, whether we're in mental health courtroom or a regular courtroom. In terms of Bharwani and from clinical standpoint, from forensic psychiatric standpoint, I think it fundamentally did not change of how we conduct assessments or how we apply the test to our assessments, but it did provide a nuanced summary to really pay attention and really consider meaningful participation and presence of the individual during their criminal justice process and the context of the case, the complexity of the case. I think those kind of in a nutshell from forensic psychiatric perspective summary.
And I think that brings us to time. Thank you very much to my panelists and for having us.